Good morning, all. Welcome to this talk on enforcement in the private rented sector. I had a look at the delegate list in advance and was very happy to see so many familiar names. We had 400 signed up and we have 267 logged in so far. So we may see more trickle in as the session continues. Andy and I hope to keep you engaged over the next nearly 1 hour. He'll be talking first about matters arising under Part 1 of the Housing Act 2004, and I'll be talking second, trying to keep up the momentum with matters arising under Parts 2 and 3. Underlying everything we'll be talking about today is the raft of changes to be made by the Renters' Rights Act 2025. So if you were hoping to learn more about the altered landscape, you're in the right place. In the usual way, you'll all receive a copy of the slides afterwards, so don't feel the need to fastidiously jot everything that you see written. With that, over to you, Andy.
Thank you very much, Riccardo. I noticed three hands are up. If there is any issue or any problem, I don't know if people are able to get into the chat function, because normally what happens in these events is that the person who's not speaking will be able to keep up to date. In fact, there's now 4. Perhaps I'll ask Corey. I'll see if we can unmute to see if there's any issue that's coming up.
All fine.
Is everything okay?
Yeah.
Oh, excellent. Okay, that's great. As Riccardo said, we're going to be speaking on the Housing Act 2004 primarily, in particular in light of the changes that we've seen. In terms of the division of labour, we have myself dealing with Part 1 of the Housing Act of 2004, which will be a very brief overview of that, and more particularly, of course, the changes being brought in, and to some extent, which have already been brought in terms of the investigatory powers by the Renters' Rights Act of 2025. You'll also see some slides on the database, the Ombudsman, and the impact of the Building Safety Act. I think, to be fair to Riccardo and to make sure we get through the session, those are likely to be purely on PowerPoint alone. And so if there are any questions, of course, please feel free to ask them. But I'm likely to concentrate on the bit you can see in bold, and Riccardo will be dealing with the licensing issues under Parts 2 and 3 of the 2004 Act, offences and defences. So, Housing Act 2004. Let's have a look at an overview. As we know, we've had it in force for what's coming up for 20 years on the 6th of April of this year. It's a system, of course, for assessing housing conditions in the private sector, and largely relies on the concept of hazards, Category 1 hazards and Category 2 hazards. And you can see on the screen in front of you the definition of hazard set out in Section 2, subsection 1 of the 2004 Act, which is any risk of harm to the health and safety of an actual or potential occupier of a dwelling which arises from a deficiency in the dwelling or in any building or land in the vicinity. And you can also see there is expanded responsibilities in terms of 1, to review housing conditions in the area, and under Section 4, to inspect to ascertain whether a hazard exists if it considers it appropriate. And we can see as we look at the changes to the Act that will be slightly redefined by a new Section 6A. So that's really what the current system does. As I say, it's focused on the private rented sector. And basically, if the inspecting officer is of the view that a Category 1 hazard exists, there is, as you know, a duty to take enforcement action. And you can see the various options there, the 7 different options set out. And that is a duty to take enforcement. If, however, it's a Category 2 hazard, then there's a power to take enforcement action under Section 7. And again, you can see the 5 options that are set out there. In terms of practicalities, you'll also notice from the 2004 Act and Schedules 1 and 2, there are references to the service of notices, revocation of notices, and variation of notices set out therein. And in terms of financial penalties, what you have in terms of the current law is you obviously have the ability to prosecute for failure set out in various parts of the 2004 Act, but you also have, in respect of certain offences, and that would include failure to comply with an improvement notice in respect of Part 1 and some other issues to do with licensing in Part 3, HMO licensing, and also overcrowding notices. You have the option of financial penalties, and that can be, at the moment, a fine up to £30,000, although, as we probably all know by now, that's going to be going up for post 1st of May offences to £40,000. And the local authority, as I say, in those issues, as far as I'm concerned, dealing with the improvement notices, the local authority can elect, rather than prosecute for non-compliance, they can elect to impose a financial penalty if they're satisfied beyond reasonable doubt of the breach of the order. And again, I don't think it'll be of surprise to anyone that in terms of procedure and appeals, that's set out reasonably clearly in Schedule 13A to the Housing Act 2004, and many of you will have had experiences of, in particular, the first-tier tribunals and beyond, dealing with such matters. And so that in itself is not going to change a massive amount in terms of process. So that's what we've got at the moment in terms of the system for the private rented sector. So what are we going to get with the Renters' Rights Act 2025? Because, of course, the headlines of the Act is very much about the abolition of short-hold tenancies and such like. But, of course, it has a very big impact when we turn to consider conditions in the private rented sector and beyond. So by way of overview, I think what I'd first want to say is that what will eventually happen, and you can see from the first column dealing with decent home standard, there is effectively an extension of the DHS from the social sector, where it's been for, I think, since 2000, into the private rented sector. And that's going to be reflected in a number of different ways, but in particular by sections 2A and 2B to the 2004 Act. And that is something that's going to be able to be enforced by local authorities. And we are looking for consultation before, I should say, the 2035 date you see at the bottom there as to the content of requirements. But it's certainly going to be something that's very much in the future. But in essence, the Act itself is going to create some wider powers of local authorities to maintain financial conditions. In terms of financial penalties, we will deal with later the new Section 6A, which allows local authorities, in addition to their work under Category 1 and Category 2 hazards, to also deal with landlords and others who are not keeping the properties in the condition they should be doing, where it is otherwise reasonably practicable to do so. And we'll see that that is something that they'll be able to take, in a sense, early action against such bodies in the future. I've already mentioned under the third column about the extension of the duty under the Decent Home Standard, and we'll see, as I say, we'll give an overview of the Type 1 and Type 2 requirements coming in due course into the system. And in terms of investigatory powers, it's one of those areas which we'll very briefly look at, but is something that is already in force. And largely, of course, deals with inspection and powers to require documents from a wide range of persons, not just the obvious landlords and managing agents, but well beyond that. So there are some significant changes coming in beyond perhaps the headline of the Renters' Rights Act. And there is also and most crucially, and again, those of you working in this area will know this, there is new guidance, civil penalties under the Renters' Rights Act and other housing legislation guidance. And this very much is going to be used alongside the existing guidance that is already being used for existing offences and existing actions. But certainly from the 1st of May, this will be the guidance to be used. It will apply to those matters under Section 249A, which, remember, deals with financial penalties. And it is also looking at, in particular, starting points, as we'll see later, for the level of fines for respective issues. And of course, it will lead and will have no doubt in many instances already have led to the amendment of local authorities' own policies as to how they proposed to deal with financial penalties and at what level they propose to set them at. In terms of the phases, as we've seen, although we've already had, as it says at the bottom bullet point of column 1, the investigatory powers in since the 27th of December, we are looking, of course, at a new tenancy regime in the private sector with the abolition of assured short-hold tenancies. We are looking about obligations on local authorities to report to the Secretary of State on enforcement activity. And we are looking about the expansion of civil penalties and the increase to £40,000 and rent repayment orders being possible to be made against superior landlords. Later in the year, we are seeing probably an introduction of the Section 6A matters, but also we're going to be seeing the database for private landlords to register and the introduction after that time. I've given the suggested date of 2028 of a new private sector landlord ombudsman service. And even later than that, of course, what we're looking at is the extension of the Decent Home Standard, as I've already mentioned, to the private rented sector, and consultation on that coming up in the next couple of years as to the level of that and as to the requirements that are expected to be made by the private rented sector on those issues, which again I would stress is the private rented sector, not the registered providers of social housing or private registered providers of social housing. In terms of guidance, I've already mentioned the one guidance, but there is lots of guidance that no doubt those of you invested in the area will have already in mind. And you will, for example, see that there is one on the enforcement of the new tenancy regime, tenancy system under the Renters' Rights Act, as well as one on investigatory powers. There's probably not a lot to be said about these matters of guidance, apart from the fact that they are there and they should obviously be used and applied as and when appropriate. And in terms of investigation powers, which we see in Part 4 and Chapter 3 of the Renters' Rights Act, sections 114 to 136, in many respects, deal with very similar powers in terms of investigation, access to premises, access to documents, as trading standards officers already enjoy in relation to their field of expertise and competence. And it's really an expansion on what we've already seen in, for example, Section 235 of the Housing Act 2004. And to some extent, some of that, such as Section 114, the power of local housing authorities to require information from a relevant person, is not greatly dissimilar. Where you do see signs of an expanding scope is in Section 115, looking at the powers of local housing authorities to require information from any person, and that would include, for example, banks, utility companies, and others in written form, and specifying what is required and the consequences if they don't require. And therefore, that's been an expansion that will, the point is that it's meant to greatly assist to ensure that the standards in the sector are maintained and improved. Section 126, which you can see on the slide, again, by way of example, grants wider powers than an authority presently has for business premises and access to business premises, but also, sorry, for residential premises, but also the wider powers are in respect of business premises, which you see elsewhere in Part 3. Effectively, what you are looking at in particular is ability to enter premises in the right circumstances, with or without a warrant, in respect of certain housing matters. However, the last bullet point is important because, of course, not only do these new powers need to be properly set out in your own policies and procedures so that a person can see how they're being applied and why they're being applied, but also you need to obviously ensure that the information obtained is stored securely, because of course there are data protection issues which will inevitably be employed because of these greater powers. So in summary, what we see under the Renters' Rights Act is a more robust and a clearer set of circumstances in which a local authority can access premises, business or residential, and in which they can obtain documentation for the purposes of their works under the 2004 Act, and the fact that there's an imposition of criminal liability in respect for obstruction and non-compliance. And as I said earlier, I would very much stress the need to have a look at the guidance that the government have produced in November last year to see how, in practice, it's anticipated that that will be employed. So in terms of enforcement, and that's obviously what people are often primarily concerned with, just to say that Section 107 of the Renters' Rights Act includes the duty of every local authority to enforce the landlord's legislation in the area. And that's perhaps not too surprising. You're entitled to use those revenues that you receive because of your activities in an area to meet the cost of the housing enforcement work in the private rented sector. And as you can see, also the procedure for issuing penalties and bringing appeals to the FTT will be essentially the same as it is at the moment. There will be a different schedule in respect, as we'll see, of the Section 6A powers, but it will be largely same as what presently is used. You will be able to enforce outside any geographical area of the local authority under Sections 108 and 109, and there is an existing requirement to report to the Secretary of State on the exercise of those enforcement functions. The notion, of course, being that they want to keep a fairly good oversight as to what's happening. So in broad terms, obviously, there's the obligation on local authorities to enforce landlord legislation. And in terms very quickly of new breaches, we see the 88 Act has a whole range of different breaches for which landlords, their agents, and those acting on their behalf can be fined. Just to give one example, requiring a tenancy to be ended verbally when you're not entitled to do so, a failure to give tenant written notice that a specified ground might be used where this is required by law, etc. A whole range of new breaches that will be raised in that list, and fines up to £7,000, and new offences following on from those sections of the Renters' Rights Act at sections 15 and 16. And you can see the list there of the 5 offences, such as reletting or remarketing a property within the 12-month period from which it's not entitled to after using grounds 1 or 1A. In other words, you've effectively misled the process as to why you wanted recovery of the property. And so those are new offences which I appreciate don't really go to Part 1 of the 2004 Act, but it's as well to be aware in terms of landlord legislation, the expansion of that within the Housing Act of 1988. But what we're more concerned with, of course, is the changes to the Renters' Rights Act in respect of Part 1, and in particular the expansion of the decent homes standards into the private rented sector. And the idea is that that is done by sections 2A and 2B of the Housing Act 2004, which imposes requirements on various persons, including landlords and their agents, to carry out certain matters set out in both the legislation and the requirements which will be imposed by the Secretary of State. And the government's roadmap, and that is a document that you can find online, says that this is going to be dealt with after consultation, and it looks like we're going to be certainly waiting beyond 2028 before we have the full details as to what is needed. But in terms of what we may hazard a guess will be needed, we can see from Section 2A, we can see that the Secretary of State can specify by regulations matters concerning the state of repair, things to be provided for use by or for the safety, security or comfort of persons occupying the premises, and the means of keeping the premises at a suitable temperature. So that is, in a sense, the fairly obvious range of subject areas which the Secretary of State will be concerned with. In other words, making sure a property is in good condition and is safe. And in terms of the approach to these new requirements, it's going to be very similar in one sense to the Category 1 and Category 2 hazards that we already see in Part 1 of the Housing Act, because it's going to have Type 1 requirements, which the Secretary of State considers appropriate to be subject to enforcement as if they were Category 1 hazards, and those which are less serious, which the Secretary of State considers appropriate to be subject to enforcement as if they were Category 2 hazards. So we can see those as it is at the moment. And we see, as I say, the legislation there in Section 2A of the Housing Act 2004. In terms of what those requirements will apply to, or I should say what premises they will apply to, well, it will apply to qualifying residential premises, dwellings let under a relevant tenancy. Relevant tenancies are going to be the assured tenancy regime, the assured agricultural tenancy and Rent Act tenancies. There are still, it always surprises me, an awful lot of Rent Act tenancies remaining. I think the latest estimates that I've seen are there are approximately 75,000 Rent Act tenancies remaining, although in terms of the sector as a whole, that's fairly small because, of course, the sector as a whole is looking in the region of 5 million units of accommodation. So dwellings let under a tenancy will be subject to these requirements. HMOs let under a relevant tenancy, single occupant HMOs, those properties used for the homelessness provisions under Part 7 of the Housing Act 1996, although I stress not dealing with social housing, and common parts in relation to a relevant tenancy will be covered by the requirements for which regulations can be imposed, conditions can be set, and enforcement can be taken by the local authority. And as you can see there, those are the definitions. And it also, I should have said, includes supported exempt accommodation, which you can see in the right-hand column. And we'll see that there will be a duty to inspect a Type 1 requirement and the duty to take enforcement action, just as there is at the moment with Category 1 hazards. And with the Type 2 requirements, there'll be a duty to inspect and a power to take enforcement action. So again, very similar to a Category 2 hazard, although I do stress there is a duty to inspect the premises before coming to that conclusion. In terms of financial penalties, we're looking here primarily at Section 6A. And as I say, Section 6A is the section which looks at whether, in fact, a landlord or agent, or indeed even higher, should have actually taken action, and it was reasonably practicable for them to take an action, as you can see in the first bullet point, to secure the removal of the hazard. As I say, this is probably one of the more exciting developments of the Act, in the sense that it gives you the options of dealing with matters either in isolation by saying, yeah, this is something that we're going to impose a penalties because you should be doing this, and it should have been something that you should have done, without having to go down the improvement notice or prohibition order, etc. route. Or if you wish to, of course, you can do both, and it therefore gives a greater impetus to a proactive local authorities enforcement regime in terms of setting the standards in the private rented sector in their area, although as we've seen, they do have the powers outside the area as well. So that is the first bullet point. The second one talks about being able to impose a financial penalty of up to £7,000. And that may relate to more than one category hazard on the same premises, more than one type 1 requirement on the same premises, or any combination in relation to the failures by the relevant person in respect of this issue. So a very important power, and one that, as I say, allows the local authority to be very preemptive in their approach to private sector enforcement, and one that's actually likely to lead to a lot of appeals before the first tier tribunal as to whether matters were reasonably practicable, or as to whether the matter has been properly set down in a category 1 or type 1 requirement assessment, and whether that has been done appropriately. And of course, as always, of course, whether the relevant policy of the local authority and the statutory guidance has been properly followed and applied. In terms of procedure, we'll see that there's a notice of intent within 6 months of having given sufficient information to take enforcement action, which, as you can see, the things it must include: the date on which it is given, the amount of the proposed penalty, the reasons for imposing the penalty, and information about, as you might expect, the right to make representations. And they have 21 days to do the latter. And having done that, the local authority must then decide whether it wishes to propose to impose a financial penalty and give a final notice requiring payment within 28 days. They can withdraw that notice or reduce the amount of payment required at any time. And as I say, there is a right of appeal against such a final notice, and it's by way of rehearing. Although, as you'll know from the existing process with first-tier tribunals, a lot of respect will be given to a local authority where it is following a policy which is both well-researched, fairly extensive, and makes sense as to what the local authority is trying to achieve. It is a civil debt if it's not paid, and therefore can be pursued by way of a judgment, by way of a charge on the landlord's property, or any other sort of enforcement one would expect from a debt in the county court. And it may be applied towards the administrative and legal costs and expenses incurred in or associated with carrying out any of its enforcement functions. And otherwise, it must be paid to the Secretary of State. So I think it's fairly obvious where it's useful to use the financial penalty proceeds for. In terms of key takeaways from the changes that we've seen, clearly there probably needs to be some training for appeals. Now, that's not just a plea for training because of the new appeals that there will be, but also more generally because of obviously the updated guidance and the more staged processes there will be, and the guidance that we see for financial penalties generally have very much a starting point approach and a staged approach, and therefore you'll often find that its starting point will be, for example, £25,000. And it's a question of whether, in fact, that accords with your policy and whether, in fact, any variations, there is justification for that. But it's, as I say, does include the Section 6A matters, and indeed the Type 1 and Type 2 requirements that we have already seen. It clearly means that any policies that you obviously have at the moment, and you'll have to have them if you're a local authority, in terms of your financial penalties, will have to be developed. And I suspect most of you who are from local authorities have also either been engaged in that or have already done it. And there is likely to be appeals, particularly in the Section 6A area, as I say, and as I said earlier, as to whether in fact it was a reasonably practicable measure that the landlord could have, or the party concerned could have dealt with, or not, and of course whether the quantum is appropriate and in accordance with the guidance, both statutory and local, and even if it's not, whether it's appropriate for other circumstances, and that will be something that will be no doubt coming up. I mentioned at the start, there are other changes that one sees, and I was just going to flick through these and allow you to read them at your leisure, because you will, as Riccardo said, get these with the after this session, and you'll also, in any event, I should say, be able to see both the recording of this webinar and indeed the slides if you go onto our website and look at events. It will have those in any event. And so you'll have seen, we expect this in late 2026. You'll have to register if you're a private landlord. There will be fines if you don't. And you must provide details, not only obviously of your contact details, but obviously to ensure the safety of the property with the various certificates that are required. And it does not, and this is very much stressed, replace Part 2 and Part 3 licensing schemes, which Riccardo will deal with shortly. Similarly, there will be an ombudsman, which we don't need to be concerned about, particularly now, but it's not clear who will run it, but it will be mandatory for private sector landlords of assured and regulated tenancies to join, and there'll be various powers that one sees with existing ombudsman that you can see on the slide in front of you. And the Building Safety Act has been in for some time in terms of high risk buildings. That's those of 7+ stories. And you can see already there's been a number of cases that have come up in the recent last 12 months dealing with remediation orders and such like. And it's worth having a look at that. But of course, that's been in for some time now, and therefore is probably well considered by local authorities, but it is worth, in the context of looking at the private sector and improvements in the sector, appreciating where we're at in terms of that post-Grenfell approach to higher risk buildings. As an overview, you can see there, and in particular the use of the HSE to have the enforcement powers and such like. I'm going to end it there, and Riccardo will now be taking over with, I think I'm doing the slides, so I hope I can get it done properly, and dealing with Housing Act 2004, Parts 2 and 3. Over to you, Riccardo.
Thank you, Andy. As Andy says, I'm looking at licensing. So if we could start with my first slide, please. Everyone here is no doubt familiar with the HMO licensing regime. There are two. The mandatory regime governed by the 2018 order, which makes all HMOs occupied by 5 or more people in 2 or more households a prescribed species of HMO, and the additional licensing regime, which permits authorities to prescribe their areas or part of their areas as subject to licensing, so that HMOs that do not meet the prescribed description must also be licensed. So this is ordinarily for smaller HMOs. The order of things is that those operating such HMOs must apply to the local authority for a license, must pay a fee, split into 2 parts, one on application and one when the authority indicates it's minded to grant the license. And we have the very familiar requirement that authorities are satisfied as to the applicant's fitness and propriety to be a license holder of an HMO, and the necessity that the property is suitable for use as an HMO. So we're looking at 2 things: the applicant and the property in question. Line 1 of this slide: managing or having control of a an unlicensed licensable HMO gives rise to a criminal offence. There are three species of offence. This is, as the slide says in the top line, the old Section 72. It's here for illustrative purposes. We'll look at the new Section 72 in a moment. And underneath the three offences, we've got the two statutory offences. So the three offences are the one I mentioned a moment ago: operating an unlicensed licensable HMO, knowingly permitting an extra person to occupy what is otherwise a full HMO, and failing to comply with a condition of the license. The two statutory defences are outstanding applications, either for a temporary exemption notice, a 10 on the slide, or an outstanding application for a license itself, and what we see much more regularly on appeal to the FTT, a reasonable excuse defence, which presently applies to all three species of offence under Section 72. And at the bottom of the slide, we have the punishment, depending on the jurisdiction, depending on the forum that the local authority has elected. If the local authority elects prosecution in the magistrates' court, unlimited fine. If the local authority elects notice of intent and final notice under Section 249A, currently £30,000 penalty. In order to understand any of that, we had to read, thank you, Andy, the unreadable Section 263. This is the first half of it, or at least the summary of what the first half of it says. The person in control is the person receiving the rack rent in some way or other. So control, or perhaps I'll put it this way, the easiest way of thinking about control is that it's all about actual receipt of the rent, irrespective of ownership. We have a couple of examples of that. The first is the second line, and the third line, the agent, who ordinarily won't have any ownership of the property. And the second is from the Global Guardian's case, which is cited at the bottom of that slide, which is the point that's taken quite starkly in the upper tribunal, that it's not necessary to own an interest in the property to be the person in control. We have to compare that, next slide please, Andy, with being the person managing, which is all about ownership. The descriptions of what or of who can be a person managing start with owner or lessee, owner or lessee. The interesting point to note is that those two terms are defined. An owner is anyone who has a freehold interest or a tenancy with an unexpired term of at least 3 years. So you can have people who are owners that wouldn't ordinarily, colloquially, be understood to be owners. And anyone who is a tenant is a lessee. So again, a broader description than the one that's ordinarily used in normal parlance. Next slide, please, Andy. This is the novelty. That section is dramatically changing by the Renters' Rights Act. Parliament hasn't touched the person managing or having control definitions. So that stuff still exists in exactly the same way that it always has, which is quite nice news for those of us who have finally worked it out. But Parliament has now also introduced new ways of capturing those who are in charge, I use that word neutrally, of property. So the section is now split up. You have to read subsections 1 and 1A together. What we see in 1AA is the existing provision. This is the top of the slide, for the person managing or having control. So anyone who's spent time working out what section 263 means gets to keep that knowledge. And then we have the first novelty in subsection 1, capital A, small b, the purpose of which is to make immediate landlords explicitly liable for non-licensing offences. Those will be rather, the distinction between the first category and the new second category is maybe illusory. It's extremely unlikely that you're going to find a person who is the immediate landlord, who is not also a person managing or having control, but in the very least, it will make it easier to satisfy evidentially without having to go through all the various hoops that 263 brings up. The effect of subsection 1b is much more dramatic. This is here to cure the problem that was noticed in Rakusin and Jepsen in the context of rent repayment orders. It's catching superior landlords, and the government said, or the minister said in Parliament during the passage of the bill, that the purpose of it was to tackle sham rent-to-rent arrangements. But of course, it's going to capture a lot more circumstances, not just limited to sham rent-to-rent arrangements. In principle, it could capture a freeholder who lets on a 999-year lease, where someone at the other end of the ownership hierarchy is letting the property as an HMO. Not clear whether that was properly thought through the passage of the bill. But where it will help is where a freeholder grants a lease who grants a tenancy, and the lessee, sorry, the lessor, the person in the middle, is a company without assets. Because as we saw in Rakusin and Jepsen, the consequence is that the local authority can't go against anyone. There's no effective remedy. What is now the position is that the local authority can go against the person at the head of the chain, who is someone who is likely to have assets, likely to have a presence, likely to be someone against whom enforcement action can be taken. And the government, in some of its new guidance, Andy mentioned it, has said that responsibility may rest with the superior landlord as well as, or instead of the immediate landlord of the occupiers, giving to local authorities a pointer that those who may be liable for the non-licensing offences could be the immediate landlord and the agent, as they always were, but also now any superior landlord. The two other offences, the bottom two sentences on this slide, the over-occupation offence and the non-compliance offence, are unchanged. Over the page, please, Andy. The defences have also changed. So we still have the 10 defence, the application defence, in subsection 4. So 10 sought, not determined, licence sought, not determined. And we still have the reasonable excuse defence, but it's been split up. The substance is the same. The principal point is that the person operating, so the person under the old rules, and the immediate landlord, they apply the reasonable excuse defence. The novelty is that the superior landlord has a new and different defence. That's subsection 4b, right in the middle of the slide. There are three things that the superior landlord can rely on to defend, to raise as a defence to the new section 72 offence that captures the superior landlord. The first is that he didn't know and had a reasonable excuse for not knowing that the property was an HMO. So we know that the FTT is going to be particularly interested in the steps that the landlord took to inform himself. It's not going to be enough to say, I did not know, but the superior landlord would have to show, I had a reasonable excuse for not knowing. The second available defence is that the superior landlord took all reasonably practicable steps to ensure that the HMO was licensed. Now, it's unlikely that the superior landlord himself is going to be entitled to apply for a license, but it will probably capture the I bothered my tenant on the following dates about licensing and tried my hardest to ensure that my tenant did make an application. And the third of the superior landlord's defences is the sort of catch-all. He had some other reasonable excuse for failing to ensure that the HMO was licensed. Now, this is an interesting defence because the position under the existing regime, as noticed by the Court of Appeal in Palm View and Thurrock, is that it's the operation of an unlicensed HMO rather than the failure to seek a license that gave rise to the criminal offence. Now, the focus is going to be slightly different for a superior landlord who probably won't be operating the unlicensed HMO, hence the reason for needing to change the statute in the way we've been describing. But this is the classic reasonable excuse defence, except that instead of focusing on operation of an unlicensed property, the person running it, local authorities dealing with it, and the FTT in determining on it have to focus on whether the superior landlord has a reasonable excuse for not licensing or for failing to ensure that it was licensed. The new subsection 4C, which I haven't noted on the slide, so do take note, makes it explicit that relying on a term in the tenancy agreement relating to occupation of the property isn't good enough. So the superior landlord can't just hide behind clause 1 saying, don't use the property as an HMO. That's not going to be good enough. The explanatory notes to the Act say that the purpose of this provision is to ensure that the FTT doesn't refuse a rent repayment order. We're in the licensing context, but it's the same purpose applies. To ensure that the FTT does not refuse a rent repayment order against a superior landlord solely based on the existence of such a term. So that sort of term might help, but it's not going to be the end of the question. It's not enough. The reasonable excuse defence, this is subsection 5, as it applies to over-occupation and non-compliance, stays the same. So too the unlimited fine. In the magistrates' court, the big change here is that the guidance indicates that there will be a statutory instrument changing the 249A limit from £30,000 to £40,000. I still haven't seen a draft of that statutory instrument. Andy, could you go to my next slide, please? You've heard from Andy, and you'll no doubt have seen that there's new statutory guidance which gives recommended penalties with effect from the 1st of May. The title at the top of that slide is the title of that guidance, if you want to find it. But I found that if you Google guidance, Renters' Rights Act, you get it. So this new guidance comes into force with effect from the 1st of May. For the offences that we've been looking at, the suggested starting point is £17,000 for non-licensing of an HMO, and as we'll look at in a moment, £12,000 for non-licensing of a Part 3 house. The new guidance makes it clear that authorities should create a new policy, which seems to me will have to sit alongside the existing policy, with the new policy dealing with the post 1st of May 2026 world. The way this will work, if I've understood it correctly, is that the old policy will apply to offences that occurred before the 1st of May, and the new policy will apply to offences that occurred after the 1st of May. It's not the date on which the local authority serves the notice of intent or the final notice that matters, but the date on which the offence that's alleged by those notices occurred. I understand that Justice for Tenants has put together a model policy. You may want to speak with them about that. You may also know that the Sentencing Council opened a consultation earlier this year into giving sentencing guidelines for the first time, specific sentencing guidelines for the first time, for a number of Housing Act 2004 offences. The maximum proposed fine will be £2.4 million for companies with a turnover of £50 million or more, going all the way down to 600% of the relevant weekly income for an individual. That range is obviously enormous. If you have something to say about that, the consultation closes on the 9th of April. You can find it online. Next slide, please, Andy. I can take section 95 much more speedily. These are the selective licensing offences. So as everyone here knows, an authority can designate all or part of its area as a selective licensing area. If it does so, every property caught by that designation requires to be licensed. And then we have the usual applications to be made to the authority, split payment of a fee, requirement on the authority to consider fitness and propriety, and to consider, no, only fitness and propriety in this context. The changes that are made by the 2025 Act are identical to those made in section 72, except that there's no over-occupation offence in the Part 3 world. So all the subsection numbers are -1. Otherwise, you can read everything across. Having taken you through all of that, none of this is yet in force. The roadmap that Andy mentioned during his talk says that it will be brought into force on the 1st of May 2026. But again, there's no draft of the statutory instrument, so we don't know that for certain, except that's what the government has told us. Next slide, please, Andy. This change, the change that this slide looks at, arises from abolishing section 21. So this is this section 21 stuff, if I can call it that, is the front page, the front piece of the Renters' Rights Act 2025. It's what was trailed in advance. It's what most of the publicity has been about. Under the old regime, a landlord who was operating unlicensed, licensable property couldn't give a Section 21 notice. There are now no Section 21 notices with effect from the 1st of May 2026, subject to very short transitional provisions. So the position is that no one can give a Section 21 notice, licensed or no. Because of that, Sections 75 and 98 have been repealed. When I first saw that, I thought it was surprising, but the reason it's not surprising when properly considered is that there was never any limitation on the landlord of unlicensed property giving a Section 8 notice. What's happened now is that entitlement on a landlord has been bolstered by the introduction of ground 6B, which has this effect. If a property requires to be licensed and a landlord has applied for a license, but his application was refused, or he had a license and his license has been revoked, he has to give not less than 4 months notice. That's section 8(4)AA, which gives him a mandatory right to possession with the purpose of stopping the offence being committed. I haven't seen anything in the statute or in the guidance that suggests that a landlord will have a reasonable excuse defence during that 4-month period, but I expect landlords to run that argument. The tenant who is evicted under ground 6B has a new entitlement to compensation under section 11A. That's the bottom line of the slide. So expect to see some interesting case law on that. The important point to note is that this entitlement to possession only applies to those who have attempted to regularize the position. So a person who never applied for a license can't rely on ground 6B to get vacant possession on the basis of a risk of prosecution or a financial penalty. None of this is yet in force, but again, it's all expected to come into force with effect from the 1st of May. My next slide, please. We've had some of the information provisions from Andy. These are the few in-force changes. They came into effect on the 27th of December 2025. They are in sections 134 and 135 of the Renters' Rights Act 2025. The chronology is this. In 2006, the government produced a document called A Decent Home, Definition and Guidance for Implementation, which was all about introducing a decent home standard to public housing. The Renters' Rights Act picked that up and introduced new sections 2A and 2B. You heard from Andy on this, to the Housing Act 2004, to go with the specified standards that the Secretary of State is empowered to specify, to create regulations to specify. Authorities can now demand documents relating to property conditions as amended in section 235. That information can then be used for other enforcement purposes, as in 237. The explanatory notes talk about council tax, housing benefit, and tenancy deposits. And the Act talks about unlawful eviction, the new no ASTs rule, the new no short tenancy rule, redress schemes, banning orders, rent repayment orders, and the new private rented sector database, which Andy touched upon. So what we're seeing here is explicit permission for discussion between the various arms of the authority to create, it seems, a more joined up approach to enforcement. The obvious example for me is that the council tax department is informed that the liable person is someone other than the owner. The authority should be feeding that information to licensing to investigate, because it makes it apparent, I suppose I'll go as high as that there is someone in the property who may well mean that the owner needs a license. It's all here to make local authorities be more proactive and not just reactive. And I appreciate, should say, when I say that many local authorities already are. And the final changes to the powers of entry in section 239, the important point to take from it is that local authorities no longer have to give advance notice to the owner of their intention to enter property. They have to give notice after the event within a reasonable period. So this is there to deal with those cases of unscrupulous landlords using advance notice of an authority intending to inspect to try to hide evidence of their criminality, which too often means unlawfully evicting everyone whom the local authority might have been able to talk to. And that, at 12 o'clock on the dot, is the end of my talk.
I should just say thank you very much, Riccardo. You may have seen in the Q&A.
I have seen it. It's a long question, and Robin, I have your email address, obviously. So let me, I've copied your question out of this Q&A panel so I don't lose it when this discussion is closed, but I will write you an email afterwards to answer it.
And there is also some raised hands. Is it possible for people to, if they want to ask anything relatively quick, perhaps now, to put it in the Q&A, if you've got access to it?
Well, because Andy said that, Robin, I've had a chance to read your question. I think this is terrible. I just looked at it this morning. I mean, I think it's terrible in the sense that I think it's going to catch lots of people who don't think about their property at all because they've effectively given it up. I think in answer to your question, what should they be doing? They should be communicating with their leaseholders and working out what the circumstances are relatively regularly. There are easy steps like looking at the local authority's website to see whether a license has been granted, because local authorities are required to publish that information. There are slightly more difficult and involved steps like writing to the authority and saying, has a license application been made? Has an application for a 10 been made? And then there's, as I said first, the broader writing to the to the lessee periodically saying, do I need to be worried about this? Have you done this? Are you an HMO? Are you a Part 3 house? Have you applied for a license? Anything more specific than that, Robin, you also have my email address and my phone number. Do get in touch.
I'm very grateful for that. Could I ask those with raised hands, because I know it sounds simple, but I don't think we have the facility to unmute. If, as Riccardo said, if anyone has any questions, you've got on the screen, hopefully the screen when I've stopped playing with it, the email address is in front of you. I'm sure I speak for Riccardo, more than happy any short inquiries to answer those, and if you'd prefer to have a chat, I'm sure we're both happy to do so if you want to put your details on that. So I'd be very grateful if you do that. As I indicated at the start, well, not only will you have access to the slides, and bearing in mind, of course, this is a talk that Riccardo and I gave in some senses very similar to a local authority recently with our colleague Tara O'Leary, which took half a day and was still rushed. It's obviously a very involved subject. So obviously there's bound to be lots of questions. Please, by all means, if you want to drop one of us a line, please do so, and you have the details there. I don't think there's anything more in the chat function or the Q&A function, so I will merely end it there, and thank you very much for all those who attended, and I hope you found it useful. If there are other things you'd like Chambers to be talking on in this area, then please feel free to do so. In the meantime, have a lovely day and rest of the week, and we will hopefully see you all soon. All the best.
Thank you very much.